Well, hello again, people. Welcome back to the channel. So, now I recently watched a video when the YouTuber said that a claimant was ordered to pay the sum of £4,000 in costs to the defendants, who are the Met Police, because he failed to comply with a court order. That is not what was ordered. We're going to look at the civil procedure rules and what the court actually ordered. But first, I'm going to play you the clip. Have a listen.
In a recent video, I told you all about Marty Blackborough's latest setback. Marty thought he was in line for compensation. Instead, he's now been ordered to pay £4,000 in legal costs to the Metropolitan Police for failing to comply with a court order.
The claimant, Marty, was ordered to pay the sum of £4,000 in costs to the Met Police, the defendants, because he failed to comply with a court order. Now, court orders have legal consequences. For me, if you're going to explain litigation publicly, you need to get your facts correct. So let's have a look at the letter which was written by the claimant solicitors to their client. I want you to look at the first line, the first paragraph. The application was heard before Deputy Judge, I won't even try to pronounce his name, at Central London County Court. It goes on to say, unfortunately, the judge found in favour of the defendant, and it explains why. Let's have a look at the next page. It tells you, well, you can see what was ordered, but I want you to look at the last two paragraphs, which says, further, you were advised that in the event the defendant is successful with the application, a court may award them their costs of the application. Despite highlighting the defendant's failure to comply with the rules, the judge ordered that you pay the defendant's costs of an occasion by the application in the sum of £4,000 by 21st of March 2025. All right. So you can see what's happened. The application was heard and the judge made the order in favour of the applicant. So let's have a look at the CPR rules, in particular, Part 23, but 23.1, definitions. Application notice means a document in which the applicant states their intention to seek a court order. On this occasion, the applicant was obviously the defendant's solicitors, or the defendants issued an application to seek a court order. Hearing means the occasion on which any interim or final decision is or may be made by a judge, at which a person is or has a right to be heard in person, by telephone, but by video or by any other means which permits simultaneous communication. So basically, the application was issued, a hearing date was obtained, and the matter took place before the district judge, as we saw in that letter. Respondent means the person against whom the order is fought. In this case, it was the claimant. So what happens after that? Well, you got an order for costs. Costs is dealt with under Part 44 of the CPR, the Civil Procedure Rules. Here we're looking at Part 44.2. 1. The court has discretion as to A. Whether costs are payable by one party to another. In this case, the court thought so. B. The amount of those costs. We know that is £4,000. And C. When they are to be paid. We know that as well. You saw in the letter. The court decides, if the court decides to make an order about costs, the rule is the unsuccessful party, in this case was Marty, will be ordered to pay the costs of the successful party. And the court might make a different order. That doesn't happen. So this here is incorrect, what this person is saying. Have a listen again.
In a recent video, I told you all about Marty Blackborough's latest setback. Marty thought he was in line for compensation. Instead, he's now been ordered to pay £4,000 in legal costs to the Metropolitan Police for failing to comply with a court order.
Well, I hope I've explained it clearly for you. If you have any questions, or just put it in the comments below. I'll see you in the next one. Peace.